This is the second in the series of talks that we're organising for this year, and the aims of these talks are really to address issues that people find really difficult to talk about or don't really know how to manage. And obviously wills and power of attorney are key examples of that. So this is Natalie Bird from D&H Law. Natalie's based in Thurso, and yeah, she's come down today to talk about wills and power of attorney. You can take your masks off while you're sitting down if you're happy to, and there'll be time for questions afterwards. I think that's everything. But yes, over to you, Natalie.
Thanks everyone for coming along. So I'm a solicitor and I practice in the Thurso office, and I'm a member of something called STEP, which stands for Society of Trust and Estate Practitioners. And what that means is that I just specialise in this area of law. There is nothing else I do. I just worry about this area of law. I feel it's something very important. I wish people would think about it younger. I'm on the receiving end of what happens when people don't have things in place and see the worst of it. So I'm all for getting the message across to do this as early in life and as soon as possible, really. So I'm going to talk about wills first. Sarah's going to flick through my slides for me. And again. Yeah, so the first question is why you need a will. And if you can click again, Sarah. So the main reason is that having a will is the only way that your assets will pass as you want them to. If you don't have a will, the law decides where your assets go, and it has a very clear list in order as to who is to inherit. And I think what people find most shocking is that spouses fall fourth in line. Children come first, parents come second, siblings come third, spouses come fourth. There is a general misconception that if you are married, your spouse is just going to get everything, and that is not the law. So, even if you've got a joint account, the law automatically assumes that the starting point is that half is yours and half is your spouse's. And if you don't have a will, half of that joint account will go to a child or a parent or a sibling before your spouse gets it. If you have children and you want your spouse to inherit, you must have a will. That's the only way to protect your spouse or anybody else. You don't have to leave to your spouse in a will, you can leave to anybody. From a paperwork point of view, having a will makes it much less time consuming, much less complicated, much less expensive when you do pass away. And for me, one of the other big things as well is when we make a will together, inheritance tax is 40%, and you've paid income tax on it while you're alive, and probably capital gains tax and all sorts of other taxes. There is no reason for you to pay the tax man another 40%. All you need to do is spend time with someone like me in the first place, and we can protect your assets from that. Can I have the next slide, Sarah? So the bit that's just chopped off there, the most people say to me, I'm too young to make a will. And my answer to that, if you can click again, Sarah, is that you are absolutely not too young. Anything can happen to anybody at any time, and I think COVID's really highlighted that for people. You make your will as you are today, and if life changes, come and change your will. So it's better to have a will in place for how you are than no will at all, and you can chop and change your will as often as you like, but please don't leave it until it's too late and miss that chance to not have a will. You can future plan a will, so we can word a will that has different scenarios. For example, if I have children, I'd like X to happen. If I don't have children, I'd like Y to happen. Or if my husband predeceased me, then I'd like this to happen. You can work scenarios into a will. So even if you're unsure and you're thinking, well, I won't do it this year because something might happen or this might happen, we can future plan in your will. Yeah, even if it's the most basic will in the world that just says, I leave everything to my husband, if not person X, better that than no will at all. Next slide, Sarah. Some people say to me, I don't have any money, I've got nothing to leave, there's no point in having a will. And if you can click again, Sarah, every single person has got a file with HMRC, and every single person's file with HMRC needs to be closed. Even if you are in receipt of benefits, you've got a file with the Department of Work and Pensions, and that file needs to be closed. And where I've got there, only an executor can wind up your estate after you've passed a will. So an executor is someone that you appoint in your will to do those kind of things, to close files, to do the paperwork, to do the forms. If you don't have a will, you do not have an executor, and the Department of Work and Pensions and HMRC and banks and anybody else, or the DVLA, if you've got a car, will not let your spouse or anybody else sign a form to close that account, or to release money, or to change a logbook. Only an executor is allowed to do that. And ultimately, if you pass away without a will, the only person that can appoint an executor is a sheriff in the court. And that costs a lot more money than you would have spent with someone like me making a will. You can double the cost of what it would cost to appoint an executor after you passed away. And it's just an added stress that your family do not need at a time when they're probably grieving, is to end up in court asking if you can do something that you feel you should have the right to do anyway. Next one, Sarah. Some people ask if they can get assistance to pay for a will up front. If you can click again. My firm and lots of other firms work with something called the National Free Wills Network. And that's a service that certain charities offer. If you're a supporter of a charity, effectively the charity pays our bill. And the charity would like to think that maybe you'd leave them a little something in their will for doing that. And we offer a really reduced price for the charities to do that. So we both sort of get something out of it. But you can get, yes, so you can get a will without having to fund it yourself. If, you can go to a charity. There are 144 charities signed up to this, and they're not just the big household names. Lots of local charities do it too. And we work very closely with them. Next one, Sarah. My spouse has a will and everything's in joint names. Does that cover me? And that's a question I get asked a lot. No. A spouse's will is their own will and only covers their assets. And as we talked about before, joint things do not just pass to a spouse. So 50% of the joint bank account, for example, will only cover under his will. Your 50% needs to be covered under your will. People quite often say, we'll come in and we'll do a joint will, and they are still two completely separate documents, even though we call them joint wills and you come in and do them together, and most of the time they'll probably say the same thing. They don't have to. Your will can leave to the cat's home, your will can leave to the dog's home. You do what you like in your own will, and your will only covers your assets. So just because your spouse has got one, it's no help to you whatsoever. Next one, Sarah. So we talked about an executor. What's an executor? So an executor, as we said before, is you name that person in your will. And again, you can have backup plans. You can have more than one executor. You can have, well, I'd like my spouse if they're there and they're capable, but if they're not there and they're not capable, then perhaps I'd like that person. You can have more than one. You can have, well, I'd like child A and B together to do it, so they've both got to agree on things. And ultimately, legally, only an executor is the person who has the authority to sign any paperwork for your bank, for your car, for your pension, your ISA, whatever you might have. Only an executor can sign that. The executor and the beneficiary are not the same person, but they can be the same person. If you think of it like hats, when you're acting in an executor role, you've got your executor hat on. So your spouse could be your executor and your beneficiary, but they've just got different hats that they wear at different times. Yeah, they're basically the person that's got to do with paperwork and sort out all the forms when you pass away. Next one, Sarah. I've touched on this a little bit already. What are an executor's duties? Yeah. It's twofold really. The first one is mainly to make sure the wishes in your will are honoured. They have a legal duty that if your will says, I want to leave, you know, my picture above the fireplace to Jean next door, your executor has a legal duty on them to make sure that that picture goes to the person next door. They have a duty to make sure all your assets are accounted for, that they've not missed anything. And they also have to make sure that those assets are passed to the right person. They can't change their mind, they can't change your mind, they can't change what's in the will. Sometimes executors might want to transfer the asset, the thing itself, for example, the picture above the fireplace. Some people like to leave a house in a generation and keep it going down a generation and not to be sold. And other things, it is cashing it in. Could be a bank account you just want to cash in and the funds are split. However, ultimately, it's a paperwork. The executive is there to make sure all the paperwork is done and all the boxes are ticked. Next one, Sarah. So you've got a will, should you review it? My general advice is, yes, maybe every 5 or so years. There's no set time scale, and it doesn't matter if you don't review it. It's just, it's good to kind of think about where life is. If you've had some life-changing circumstances, you've divorced, you've married, grandchildren is becoming one of the bigger ones. People are often skipping a generation now. People are living longer and feel that the children at their age that they're at are actually set up in life, and it's the grandchildren who are really struggling to get on the housing market, for example, and are at an age where they could really do with that support more than children. So yeah, having grandchildren is becoming a big change for people to change their wills. And some people may have been a beneficiary of somebody else and come into some money, which has changed. They wrote a will with the view that they only had X amount of money in mind, but actually now they're worth, you know, double, triple that. It might change your views on who you leave to and what they might do with it. Next one. This slide, I put it in, but I'm not here to sell D&H. I put in what D&H charge for this sort of thing, but we can just flip over it. I'm here to sell doing a will. I'm here to sell doing power of attorney, and you can go to any firm, but this is just ballpark figures, really, roughly what solicitors charge to do. And we offer discounts if you do like more than one together and things like that. But the budget for a will is about £200. I'm not going to sell D&H, I'm here to sell making a will. I think that's it on the wills. So has anyone got any question on wills? Has everybody got a will? Yeah. No. 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 Okay. No. No, I didn't do them. No. I mean, yeah, I see what happens.
But it's like that thing, if you have one, you know, I've got to leave, so why bother doing it?
Yeah, it just costs so much more if you haven't got one.
But then I've got the car and I've got the, what is it,
Yeah.
the van, so really,
Yeah.
yeah.
All these, it's the government
Yeah.
agencies that make life
It's-
difficult.
I can't, you see, I don't know, no, it is government make it difficult and the government get more money from it, don't they?
Yeah.
So we've just.
Life is complicated.
Oh.
I'm an American woman,
Yeah.
so if I die, he thinks that, oh, she's here, she's a British citizen, that's fine.
Yeah.
But if it's to go to have children, you're not here, but it states. Under Scots law, will that apply?
Yeah,
You can
absolutely.
write that in.
Your beneficiary can be anywhere in the world and be anybody in the world.
And the
It's about
executor-
where, yeah, your executor can be anywhere in the world, particularly these days with all this, you know, modern technology going on. It's, yeah, your executor and your beneficiary needs to be somebody personal to you, and it makes no difference to us as lawyers where they are. It's someone that you trust, knows where your stuff is, would know how to access your stuff. Someone that you feel you wouldn't mind putting around your stuff after you passed away. Some people have people that they feel really uncomfortable thinking that they were nosing through their paperwork. Yeah, it doesn't matter where people are in the world. That if you are resident in Scotland, you make a will in Scotland. Yeah, it's about where you are, not where your loved ones, trusted ones are. So we turn to the slightly longer subject of power of attorney.
No, I can see finance. No, it doesn't make no difference. All right, depends on how much you can go.
So powers of attorney. Okay, so where did I start with this? What is a power of attorney? Yeah, first good question. So it's a written document that gives someone else the legal authority to make decisions or take actions on your behalf. Next one. What sort of decisions and what sort of actions? So your power of attorney document in Scotland, they are individual documents that are written for you. Your document lists the powers that you want your attorney to have. Your document will say they can do X for me, they can do Y for me, they cannot do this for me. It's tailored to you and what you like in there. I normally draft a power of attorney document with everything in it to give you something to read through to start with, and then it's a case of you having a read through it and talking about it with loved ones or me, and taking out things that you might not feel comfortable with or leaving everything in. They're personal documents, and if you don't want someone making that decision for you when you can't make it for yourself, it doesn't go in there. Your attorney can only make decisions or take actions that they have the power to do, and only that document lists those powers. They're literally listed. So it's up to you what you want in your power of attorney document. Different types of powers of attorneys. There's two different types. You can do one or the other or both. Financial, they call it continuing for some reason, and welfare. And they are two separate documents. We can put them all in the same document if you're doing both, but they are two very separate things. And you can have a different financial attorney to a different welfare attorney if there are people in your life that got stronger skills. Some people have got children that they love, but they use this money and mess it up. But be more than happy and want them to make their welfare decisions because they still care about them, but may not be very good with money. Next one, Sarah. So financial decisions, again, you list in your power of attorney document what you want, but it's everything from paying a phone bill to selling a house and everything you could possibly imagine in between. Anything to do with money you can have in there. To do with going down the town to getting cash out of the bank for you, doing shopping for you, selling a house if you needed to downsize, for example, if you become unwell and you needed, no stairs anymore, literally anything to do with money. Welfare decisions, it's about you as a person. It's about, would you want operations? Would you want treatments? Would you want to eat that? Would you want to live there? What clothes you wear? All those things fall under the welfare umbrella. Things to your end of life decisions come into it. It's just about you and your body, and which is why it's really important that you make a power of attorney, because somebody who doesn't know you could end up making those decisions if you don't have a power of attorney document. Would you want someone deciding what sort of clothes you wore every day, what care home you might end up in, those sorts of decisions. Next one. Who can make a power of attorney? So anyone over the age of 16 and is capable, and capable's like a whole different subject, and we'll talk about that in a couple of slides' time. The only restrictions are if you've been made bankrupt, and there are restrictions on who you allow to deal with your money, because normally if you're bankrupt, there's a court order saying who can deal with your money. Someone would have already been appointed, but pretty much anyone over 16 who has capacity. And who could be your attorney? Pretty much the same answer. Over 16, not bankrupt. From a personal point of view, as your lawyer advising you, I'd want to hear it's someone that you trust, someone that cares about you, someone that knows you, And as we said earlier, you can have different welfare attorneys and different financial attorneys. You can have more than one. You can have, there's no limit to how many. You can have backup plans again, like we talked earlier, that if your spouse is there, you'd actually want your spouse to be making those decisions, or your sister, but if they weren't there, then you'd want your backup plan in place. It's about someone knowing what you would want. That's the important thing for me. It makes no difference to me who they are. All I need to hear is that you trust them and they would know what you wanted. Yeah, how many attorneys can you have? No limit, as many as you like. I think practically, if you're going to have to start having too many, can, you know, yeah, if there's more, I'd say more than about 6 can get a bit tricky. Just getting everybody to agree on everything, you know. But there is no limit, and you can have joint, you can have backup plans, you can future plan in it in case people, the first person is not there anymore or not capable in terms of helping them. I've already got a will, so I don't need a power of attorney. Your will has no legal effect until you are dead. Your power of attorney only has legal effect while you're alive. So they're two separate things. Your power of attorney just while you're alive. The moment you pass away, your attorney loses all powers. They've got all those powers in that document cease the moment you pass away. They can all be the same person again, like hats. So you could have your attorney hat on, your adult passes away, they take that off, they put their executor hat on, they sort the paperwork out, and then they're going to inherit, they take their executor hat off, then they put the beneficiary hat on. It can all be the same person, but they're very different roles, and what powers they have are very different. So yeah, your will has no relevance to while you're alive and how you treat you while you're alive. There we go. I'm married, so they can just deal with everything. Again, it's an absolute no. Being married is not a legal authority. Your spouse has no legal right to make any decisions over you. Just because you're married, you're still an individual, autonomous person, and being married does not give anybody the right to make those decisions for you. Nobody has that legal right unless you give it to them in a legal document. Too young. You're not too young. I can give you a scenario of, we've got a couple of girls in the office. One is about 22, one's about 24, and they've both got them, and they've got their mum and dad as attorneys. And when life changes and they might meet someone, they'll make a new one and appoint somebody else. And right at the beginning of COVID, I think it was in the March, when it first all happened, one of the girls was actually on holiday at the time, and the flights were all grounded, and she got stuck abroad, ran out of her euros, and mum just went down the bank with her power of attorney document and sorted everything out of her own money, out of her own bank account, and got her home, and used it for situations like that. This isn't just about age, end of life. This is just about day to day. You know, if you can't practically, physically be there, and you've got yourself stuck somewhere, your attorney can step in and sort that out. Yeah, and again, car accidents could leave you, hospitalised months at a time, and you've got red bills stacking up at home. Your attorney can go and pay your bills out of your own bank account for you. Yeah, and our young girls tend to name their parents, mum and dad, as their attorneys. And yeah, when life changes, change your document. I don't have any money. From my point of view as a lawyer, that makes it even more important that it's managed properly and not spent on things that it might not necessarily need to have been spent on, because your attorney might have been able to get you support because you've got less money. The less money you've got, the better it needs to be managed. And it's not just money, it is your welfare. And my personal view is that welfare is more important than money. From a lawyer's point of view, with money, if something goes wrong, we can sue people, we can insure against things, we can make claims against things. When someone's made a welfare decision about you, pretty much nothing I can do about it. Once you've had an operation, I'll make you happy. When does it begin? So financial power of attorneys are usually effective straight away. Unless you say otherwise, they are immediately effective. Your financial attorney can act immediately. You don't have to loss capacity in any way. Welfare is the absolute opposite. Your welfare attorney can never act until you have loss capacity. Financial is there immediately for situations like we just talked about with a young lady in the office. And also, you might have capacity, but physically not be able to get out and just want someone to go down the shop and do the shopping for you. Welfare is considered absolute paramount importance. The whole time that you can make a decision about yourself and your own body, you should do so. And nobody is ever allowed to step on your toes or make that decision for you. So, although we can put them all in the same document, they are very, very different things. And your welfare attorney cannot just make decisions, cannot take over, cannot do anything you don't want them to do. So incapable, what does capacity mean? Capacity means how you state in your document how you want your capacity to be judged. I draft mine as a default to say that 2 doctors have got to say what's capacity. But this is your document and you can say, actually, I just want 1. Actually, I want my husband to decide my capacity. Whoever you trust to decide. I think 2 doctors is a good idea from previous experience. If it's 1, it's normally a doctor from within your practice. If we're even questioning your capacity, there's probably been quite a lot going on in your life at the moment, and they've probably seen you quite a lot recently. You might have had a fall, you might be in hospital, they might be arguing about whether you can go home, whether you're capable. If it's a doctor within your practice, without even realising it, they may have half decided what they're going to write in the report that day before they've even set your front door. And they've got access to your notes, and they might feel they know you already. If it's 2 doctors, 1 has got to be out with your practice. So they will have never met you, no access to your notes, and come at you with a completely fresh set of eyes. And also, I've got clients who just have good days and bad days, and I would hate to think that one of my clients had had a report saying they didn't have capacity just because the day they happened to write that report, they didn't get good night's sleep, they didn't get breakfast, and it just affected everything. The more chances we can give you to retain your welfare decisions, the better. But as I say, they're individual documents, and you tell me who you want to assess your capacity. I can tell you what I think, but it's not my document. And capacity, yeah, it can be something that goes boom straight away in a car accident, or it can be an illness where it goes gradually. When we talk about capacity, we talk about it decision specific. And what that means is, just because you've had this report written about you saying it doesn't have capacity, if there's something that you can still make a decision about, you still do. You can be very clear that you do not like Brussels sprouts. Stop putting them on my plate. Never liked them. And no one, your welfare guardian, still can't say she's eating Brussels sprouts. But you might not be able to tell someone whether you should or shouldn't have an operation, because it's a really complicated thing. Your welfare attorney is only allowed to step in when you can't. Even if there's a written report to say you don't have capacity, you can still make your feelings clearly known. You're to be listened to. This, for us as lawyers, is just the worst. If you don't have a power of attorney, we all end up in court. The only person who can decide, who can make a decision for you, is a sheriff in a court. And it's called a guardianship. You get appointed a guardian, not an attorney. And it can be your spouse. It can be your daughter. It can be the same person that you picked. But what happens is we have to wait for a court date. We have to have psychiatrist reports, we have to have doctors' reports. We wait months and months and months, and people lay in hospital bed for months and months and months, waiting for someone that they love to be able to make that decision for them in a court. Also, with a guardianship, you're not left to get on with it as you are an attorney. You have to submit a set of accounts to the court every year that the books balance to the penny, what you spent money on, with receipts, where you spent it, and if your books don't balance, they get rejected, you get fined. It's just awful, and it costs a fortune. To get a guardianship costs about 8,000. So please look at power of attorney. What if you change your mind? If you've got capacity, you can revoke your power of attorney at any time that you like. You can change who's in it, if people come and go in your lives, as long as you've got capacity to be able to make one. The day that you make a power of attorney, you have to sign it in front of one of two people. You have to sign it in front of a lawyer or a doctor. And the reason that is because your lawyer or your doctor has to sign a medical certificate at the same moment to say that you've had capacity to make that power of attorney. And how we were talking about decision specific, I'm not signing a medical certificate to say you're in great health. I'm signing a medical certificate to say you understood the decision of a power of attorney, and that's it. So as long as you've got capacity, you can change your power of attorney, you can rip it up, entirely up to you. But we can future plan it, you know, person A, if not person B, back up plan. So it's pretty unusual that people need to change them, but it does happen. What happens to your power of attorney? So, anybody heard of the Office of the Public Guardian? So Scotland has a public guardian, her name's Fiona Brown, and her job is to protect the people of Scotland, and she's got an office of staff around her. They've got three main roles in all this. Their first is the signed document goes to them to be registered, and it's them that actually issue you with the final document, and they keep a log of who's who. And 99% of the time, you never hear from them ever again. Their second role is anybody can pick up the phone to the public guardian if they suspect an attorney has been doing inappropriate things, not doing something right, or you didn't quite know what, you just couldn't put your finger on it, something didn't sit right. You could pick up the phone back to your neighbour and say, I'm telling you, the son is spending money where he shouldn't have been spending it, or I don't know what's going on, but she keeps saying to me that money is going missing. The public guardian's got similar powers to the police. She can access phone records, she can access bank records, and she can see what attorneys have been doing. And if attorneys have been spending money or doing things with money that they shouldn't have been doing, she will take them to court and hold them to account and remove all their accounts. She's like the police of attorneys. Their third role is they want attorneys to get this right. I can write this great document for you. Years down the line, you can pick it up to use it and go, it looks a bit legal to me. I don't know what I can do and what I can't do. You can pick up the phone to the public guardian and say, can I do X? And they'll give you a very clear answer. Yes, you've got the power to do that. No, you haven't. They want you to get it right. They're there to support these attorneys as well. Next one. So where can you get a power of attorney from? They are a legal document, so a solicitor is always a good place to start. You do not have to. I mean, you can sit and write your own power of attorney document. You know, it's tricky for me as a solicitor to say do that because I've seen like really widely worded things that have ended up vague, I suppose, and really not clear what decisions people can make and not make. And ultimately, you've got to sign it in front of a doctor or a solicitor anyway. So if you're going to come to us, then we may as well support you through the whole process, really. And again, this isn't to sell DLH, but roughly speaking, this is what it would cost. So we would charge for the welfare and financial 230. The Office of the Public Guardian charge £81 per document to do their registering, and that's, you pay that whether you did it yourself, we did it, you know, any other firm did it. That's just a charge that's out with our control.